You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hi, everyone. Thanks for joining us for Let's Get Surety today. With the coronavirus and the pandemic going on, it's impacting the construction industry, both public and private sectors. In this episode, we're going to be talking about federal construction contracts and excused delays. So, co-hosting with me today, I have NASBP CEO Mark McCallum. Hey, Mark.
Hi, Kat.
Thanks for joining me today.
Absolutely. I'm really looking forward to this discussion. And I always wonder, can any delay really be excused? But I guess we're going to find out about that.
Hopefully we will. And our guests today are John Sebastian and Brian Padov of Watt, Teeter, Hoffer, and Fitzgerald. Hey, John. Hey, Brian.
Hi, Kat. Hi, Mark. How are you?
Great.
Well, thanks for joining us.
We appreciate the opportunity to speak with you all.
You know, maybe before we begin, maybe John and Brian, could you tell us a little bit about your law firm and their focus and practice?
Sure. This is John Sebastian. Watt Teeter's been in business for over 40 years. It started with just 4 lawyers, and we exclusively practice only representing contractors and sureties. And we're the biggest nationwide firm that only has those 2 practice areas. We have 5 offices. I'm the head of the Chicago office. We have an office in DC, Irvine, California, Miami, Chicago, and Boston.
So
I've been practicing law for 25 years. I started actually for a surety in-house fireman's fund 25 years ago, and then went into private practice and have been doing half surety representation and half contractor representation.
Great.
Yeah.
Brian, how about yourself?
Yes. So I also work in Watt Teeter's Chicago office under John. I've been with the firm for a little over a year and a half now. I'm in my 6th year of practicing, and before that I did insurance defense work, but I'm happy to get into the surety world.
So, Brian and John, can you tell us a little bit more about how we should be, contractors should be looking to protect their rights or understand their rights as in regards to delays and suspension of work?
Sure. Kat, this is John Sebastian. I think it all starts with whatever type of contract you have, either an AIA or what we've focused on for today, the federal acquisition regulation. So whenever a contractor is contracted with the federal government or any of its agencies, the guidelines that you turn to are the federal acquisition regulation, which is commonly referred to as FAR.
Okay.
Now, what does FAR say as it relates to delays? Well, first and foremost, you have to give notice of a delay within 10 days of the event happening. And here, what we are recommending to our contractor clients is to put the government on notice that you may be delayed as it relates to this epidemic. And the reason being is that's the first hurdle is notice.
Yeah. And is there a specific way they need to provide that notice?
Go ahead. I'm sorry.
Sorry. Is there a specific way they have to provide that notice, or can it just be a phone call? Is it in writing?
It has to be in writing to the contracting officer.
Okay.
And after you give notice, you have to make sure to gather and code all documentation. If you have a sophisticated job costing system, or if you don't, you have to set aside everything that you've incurred tied to that specific delay, just like you would with any other delay. But you have to be able to prove with supporting documentation what you were incurring as it relates to the epidemic delays. So we know that our contractors are going to have delays tied to materials and labor productivity issues. So those are the 2 things that we anticipate happening right away.
John, is there a timeline in how quickly they have to report those delays once they, kind of see them coming down the pike?
Yeah, once the initial notice is out, it's then that hurdle is done. It's just a continuing obligation to notify the contracting officer of any additional impacts. And this goes to the prejudice rule. So certain states, Illinois being one of them, follow the federal government. And what I mean by the prejudice rule is if you don't technically comply with the specific notice requirement, you have to give the contracting officer, if it's either state or federal, the basis of the claim, and that the government or owner had the ability to consider the claim and make a decision on what its options were. So if you didn't comply with the notice requirement, but the government actually knew that you were being delayed and they had the option to consider several different ways to handle that delay, then there's no prejudice. But that they didn't know, for example, you couldn't get your drywall as a result of the epidemic and you didn't put them on notice, and maybe there was another supplier that they could have had you go to, you may be stuck. But if the government knew, because you told them you were having issues and you worked with them on other options, then they can't argue, well, you didn't comply with the 10-day notice provision.
John, you had mentioned how important documentation is and getting that notice in on a timely basis. What does the prime contractor do to inform their subcontractors? Is there certain steps they should take?
That's a very good point, Mark. So you have the standard subcontract has what's referred to as a pass-through clause. So your subcontractor is obligated in the same way that the general is with the owner. So if the notice to all of your subcontractors that, hey, if you are incurring any type of delay tied to COVID-19, let me know, because I will pass through your claim to the government, but I still have to comply with the same notice requirements under the contract. So that would be a very good point and best practice for you to meet with and talk with all your subs and suppliers. Hey, are you incurring any type of delay or impact tied to COVID-19? If so, let me know and I will pass on your claim to the government.
Excellent.
Yeah, and to kind of just go along with that, sorry, this is Brian. Included with the documentation that you want to really keep, it's really important to, keep those emails and communications of the steps that you're taking to mitigate, any damages that the delay may cause. Not just, what the delay is doing to you and how it's affecting you. What steps are you taking to, kind of mitigate those damages?
That's a good transition, Brian. Maybe you can go through the 5 elements that you have to show on a federal project as it relates to an excusable delay.
Yeah, so for the excusable delay, again, we there's 5 basic elements that the contractor will have to meet to, basically support their claim. The first is affirmative proof that the delay was caused by or arose out of a situation which was beyond the contractor's control, which at this point, again, not that I'm not going to say it's relatively easy, but, it's pretty straightforward that, a contractor can show that, this epidemic is going to be causing the delay and it's outside of their control. Second, you need a proof that the contractor was not at fault or negligent. Again, relatively straightforward with, this type of situation with COVID-19. The third is you still have to have evidence showing that, the performance would have been timely, but for the occurrence of the event. So, you can't use COVID-19 as an excuse to just, if you were already going to be delayed, you can't use COVID-19 as a total excuse to delay your performance. And kind of along the same lines, again, you got to show what steps the contractor has taken to mitigate the effects of the delay. And then the final element is really establishing a specified period of time that the performance was delayed by the epidemic. And I think we'll touch on a couple of these in a little bit. So I'll leave it at that.
So, Brian, we kind of went right into excusable delays. So I assume then that not every delay is excusable. And from what you were saying, perhaps an excusable delay is a delay resulting through no fault on the part of the contractor and beyond the contractor's control. Is that correct?
I kind of lost you there. Sorry about that.
Okay.
So, Mark, I think maybe I'll take this one. What we're talking about is we don't want our contractor clients to be not only lose their right to claim costs, but we don't want them to be declared in default. So the government technically could declare the contractor in default if it's not meeting the schedule as it relates to the COVID-19 delays.
Right.
So what we want our contractor clients to do is affirmatively come forward and say, we may be delayed and we want, and this delay is an excusable delay. And I think that's what you were getting to. And excusable delays under the FAR include acts of God, but more importantly, tied to this, epidemics and quarantine restrictions. So we think it's important to put the government on notice that you are requesting an extension because of an excusable delay.
So,
are you entitled to cost for that? That's another thing.
Yeah, the word epidemics and quarantine restrictions, are those words actually in the FAR clause? Sounds like it's important to read your contract.
Exactly. So it is specifically in FAR 52.249-10, but it is also in the AIA general conditions, not necessarily quarantine restrictions, but epidemics is in there as well. But yes, most importantly, read your contract, see what it provides.
Okay.
And really quick to add on to that, we think it's important that, obviously, construction contracts aren't, stopping right now, really. People are still entering into them. It's important to note that, the COVID-19, again, its impact, while, the extent of it is unknown, you can't just ignore it when you're entering into contracts right now. Because again, that's, it's a foreseeable condition that, if you're entering into a contract right now, so you can't sit back and say, oh, well, I, didn't know the extent of the impact. You still have to, sit there and recognize that, this could take a while, to subside, and it may affect, contracting, 6-9 months down the road.
So once you give that notice and you're providing, then you're gathering your documentation, would you say it's pretty important to continue to inform the contracting officer of your status as a prime?
Yes. So this goes, Mark, back to what I was bringing up, the two concepts, strict enforcement of notice provisions or the prejudice rule requiring the contractor to show that the owner was not prejudiced by the contractor not meeting the technical notice requirements. And why I bring that up, although the contractor might have given notice within 10 days of COVID-19, what if it doesn't give a follow-up notice, or it didn't give that initial notice within 10 days? Okay. Certainly after the 10 days now. Well, as long as the government is continuing to be informed by the contractor of any potential or actual impact and has the option to consider other alternatives related to the impact, they can't argue the technical notice wasn't complied with, therefore your claim is barred.
So if you have an excusable delay and you can document it properly, does that mean you're entitled to both additional time and perhaps additional cost, or is it just one or the other, or both? What would be what is the contractor entitled to?
Brian, I'll let you take this one.
So under FAR, you're entitled to an adjustment of time generally. Again, for an excusable delay, it's relatively limited to an extension of time.
So then you may not be able to get your additional cost resulting from the delay?
Exactly.
However, we want to bring to the attention of contractors as it relates to a government project. If the government suspends the work, and this may happen on certain projects depending on what city they're in, such as Boston, the contractor can assert a claim if the CEO, the contracting officer, suspends or delays the work for more than 20 days. The contractor can assert a claim for costs, for any costs incurred after the 20 days, and if it gives notice of a claim.
So beyond suspension, are there other acts that the government might take that would give rise to potential compensation on the part of the contractor?
So there could be a stop work order. Again, I off the top of my head, I don't remember the exact provision of FAR, but you can, if there's a stop work order issued, I believe it's 24215. You could potentially, a contractor could potentially make an adjustment claim to, get some costs back. The stop work order, I believe it's limited to 90 days. That said, I know, again, but in these times, everything is, changing daily, almost hourly, in terms of different, government mandates, all that type of stuff. I believe it was last Thursday, the government provided a memorandum for contracts, and they actually modified the progress payment clause to increase the amount paid to contractors on progress payments from 80%, which is generally the rule, to 90%. So again, I think that was for essential critical infrastructure. But again, these things are really changing on a daily basis.
Right.
But again, I think the government understands the position that contractors are being put in by this pandemic.
Well, I just wanted to say with that note that we are recording this on March 31st. So last week would have been the week of March 23rd, just so everybody can kind of have a time frame as they're listening to what was just said.
Perfect. Thank you.
Yeah.
So are there circumstances where the government might take a position where the contractor is not entitled to additional time or additional cost? For example, if they feel like maybe they didn't have any control over that, this is not a procurement decision. This is more protecting health and welfare of the folks out there. As a sovereign, does that change the way they look at things?
Certainly, Mark. I'll give you two examples. First and foremost, if you don't put the government on notice, then technically you can be declared in default, and the contracting officer can make a bond claim, right? More importantly. But second, I had a panel with the public contracting section of the ABA, and I had an in-house attorney from the Corps of Engineers. And that specific question that you're alluding to was asked as it related to liquidated damages. what's the government's position? Do you always assert them? And the answer sounds like you've dealt with as well, is they, at least in his region, they always do assess the liquidated damages, regardless of how well or the underlying circumstance tied to the contractor. Now, they may later negotiate it, but they always do assert it. And as a straight line. So that's why we are, concerned that, you need to put the government on notice right now as it relates to any potential or actual delays tied to COVID-19 in order to avoid being declared in default, because I'm sure the majority of these projects aren't going as planned right now as far as progress.
Yep, and following that again, I think you may have been touching on the Sovereign Act doctrine, which again, I think what it comes down to is, again, these are again, in theory, the government could, assert the doctrine and potentially, I guess, escape liability for delay damages. But again, will they do it? Will the government, assert that doctrine? It's kind of up in the air. I mean, again, I know that there's a couple examples where, contractor asserted delay damages, regarding being denied access to a construction site following 9/11. And the government, the court found that the government was not liable for delay damages. But again, it's these are really uncertain times, so it's difficult to, 100% say that, the government might be able to, escape liability because this is what happened 25 years ago.
Right. So when you say sovereign acts doctrine, you're really referring that if the government is acting within their capacity as a sovereign, then they have immunity for those acts. Is that correct?
Yeah, exactly. Generally speaking.
So then they could take the position that they're protecting the public health, welfare, safety, and therefore they have no real accountability for the delay. Is that correct?
Yeah, again, in theory, yeah. And again, I think what we're advising our clients to do, though, is, even with that general, again, that doctrine, every situation is different. Every delay, the impacts of each, construction site, it's going to be different. And, you can't just, make this general statement, say, this is what's going to happen. I think it's really important to look at each and every, situation through its own lens to see what kind of arguments the contractor might have.
Yeah, it sounds like without that first notice, your options aren't great. So make sure you have the options and make sure you have that notice in. Sounds like, having a good relationship with your attorney and your CPA is almost even more critically important during this time. Would you agree?
I would. It's we are reaching out to all of our contractor clients to talk about this very issue, and all of your clients that are part of the association should be aware of reaching out to, as you pointed out, their accountant or their outside counsel. It's important for them to be familiar with their contract documents, to look at the notice requirements. Some of the documents you'd look at would be the main contract, the general conditions, the specifications, any statutes on public projects, and procurement regulations. So those documents will provide whatever notice may be required in order to put the owner, either government, state agency, or private entity, on notice of the issue. And if you don't do it, you may be left having no ability to assert a delay, either excusable or compensable.
Well, if anyone does want to get a hold of you or find out more information that Watt, Teeter, Hoffer, and Fitzgerald is putting out there, what's the best way for them to do that?
Our website and that's on Watt Teeter. I know that it's changed. Brian's going to give you that in a second. We do have a special link within our website on COVID-19 material, which will include a sample notice letter. It's going to be generic, so you're going to have to tailor it to your specific project. But we are putting that material up on our website. And
that's to
otherwise,
help get those notices out.
I'm sorry?
To help contractors get those notices out to the contracting officers?
To give a guideline. Yep.
So before we conclude, John and Brian, in your practices, do you ever recall a similar time where there was the impacts like you're seeing right now? Did 9/11 do anything that was kind of in a similar fashion to what contractors are experiencing now?
I did. Brian's too young for this, but unfortunately, we come from a broke state financially, and our capital development board, as well as our Department of Transportation, had no funds available. So essentially, these contractors for CDB work and IDOT work were being told to continue to work, but we can't pay you. Or in some cases, the contracting officer would say, suspend work because I can't pay you. And unfortunately, giving advice to a lot of my contractor clients was, you can bring a claim and put them on notice, but the government makes it so difficult for you to collect, it's not worth your time. So during that period in Illinois, the best way to deal with the situation is to mitigate. And if it's a complete project shutdown, you need to find ways to stop the damages. If it's removing your equipment and putting it on a different job, to stop the rental charges, securing the site, whatever it is to stop any idle time charges, that's what you need to do, because the chance for you to recover against the government entity is difficult. They make it as difficult as possible to wear you out. And that's certainly what happened years ago with our broke state. And it's what I would anticipate happening going forward as it relates to government agencies, unless legislation's put in place to address this type of situation, which, as Kat pointed out, on March 31st, we don't know of any such legislation, but it might be coming.
Great
point. So did you want to share the link for the Watt, Teeter, Hopper, and Fitzgerald COVID-19 page with our listeners?
Yep. So I don't have the exact link yet, but our website is wattteeter.com. It's WATTTIED as in dad or delay ER.com.
Well, thank you so much, John and Brian. And NASBP is also working to release as much information as we can around the COVID-19 pandemic. And you can find that on the NASBP website. That's www.nasbp.org. Thanks, Mark, for co-hosting. And thanks, John
Absolutely.
and Brian, for joining us.
Yes, thank you very much.
Yes, thank you.
It's great talking with you both.
Kat. Thanks, Mark.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.